Hello everybody, so welcome back to the English Law channel, and I'm carrying on with tort. So I'm going to look at more about duty of care today. So duty of care is not limited. There could be more categories of duty of care added in time as things change, as technology develops. What are we going to do about artificial intelligence? That's a whole can of worms, and it will no doubt open up new areas of duty of care which have not yet been ideated. All right, so let's see how the duty of care functions. So the philosophy in tort law is about deciding where losses should fall when damage occurs. It's rare that a party other than that, the one suffering the loss, has to bear the losses. So the duty of care is functioning with that sort of background. So we have to decide when we can justify going away from the general principle that losses lie where they fall and moving the loss from the innocent claimant onto a defendant, or indeed spreading the losses more widely amongst the whole of society. So the book called The Wrongs of Tort by Donoghue and Mansell, and this is what it says. The concept of a duty of care and negligence is an essential factor in determining whether it's proper to redistribute the plaintiff's loss to the defendant. This is in turn informed by the assumption that individuals should in general bear their misfortunes alone unless there is some good reason for shifting the loss onto someone else. Right, so the duty issue comes about after we've proved that someone has suffered loss or injury due to the defendant. And the issue is not ever an abstract one, because the duty of question is there a duty of care or not? And that's one that follows the basis that a person who causes a significant loss or harm to another and yet is not liable in tort because the person who caused the harm didn't have a duty or an obligation to avert causing such harm. So in briefest summary, the purpose of the duty of care is to restrict liability for reckless and imprudent behaviour. So how do we evolve this duty concept? Okay, if we're going to figure out how efficaciously the duty of concept fulfills its function in restricting a liability for carelessly inflicted loss and damage, you have to first of all comprehend the principles according to which a duty is based. So in legal history, negligence is quite a new one. It's obviously still evolving. In the past, tort claims required the claimant to demonstrate an intentional and direct interference with his person or indeed his property. But courts now see that in most cases, the harm sustained by the claimant that's caused by a careless behaviour where the defendant's conduct is not intentional can still lead to liability. So liability for negligent behaviour was recognised only in some very strictly defined situations, such as a duty of care by a physician to his patient, or if there was a fire which was caused by negligence. Outside these very limited relationships, there was no test to say whether there's an underlying principle of liability until the seminal case of Donoghue and Stevenson in 1932, where the House of Lords set out a new principle for liability for harm caused by negligence. So foresight and proximity are key here. So coming back to the celebrated case of Donoghue and Stevenson, so have to briefly explicate the leading cases which have been real milestones in developing this notion of duty of care, and point out what they contributed to our understanding of this concept nowadays. So what are the two of the core principles of foresight and proximity, as in could you see that some harm could happen if you engaged in a certain course of conduct, and were you close enough, and not necessarily geographically, the tortfeasor to the claimant to make you liable. So Donoghue and Stevenson, as I say, it's a real landmark case. So there's this neighbour principle. Now you may know that someone purchased a bottle of ginger beer and it was defective because there was a rotting snail in it, and the person who purchased it couldn't see it because of the opacity of the brown glass. And the one person bought the ginger beer, gave it to another. So the person consuming it hadn't bought it, so therefore had no contract and hadn't suffered a financial loss because she hadn't paid for it herself. But she did sustain damage, gastroenteritis. The issue was whether there was any remedy available for a loss. and would be found in the laws area governing liability for careless behaviour, which was in its infancy at the time. So the House of Lords, in this key decision, found that the claimant could get damages for her loss. The issue is whether the manufacturers owed the duty to the claimant to take reasonable care in making their product to be sure that the products were fit for human consumption. And the court said a resounding yes to that one. And they said in their summary that the manufacturer of goods has to that are going to reach the end user, who the end user doesn't have a chance to inspect the goods before consuming them, and therefore the manufacturer has a duty of care to make sure that this product, this drink, doesn't cause an illness to a person. And so that was a major contribution from that case law. So manufacturers owe a duty of care to all those who are going to use their products, even those who don't actually buy them. Those are given them for free. So we have no broad conception of negligence. It was merely a decision about a specific event of negligent conduct. The ratio decitendi here doesn't tell us why the manufacturer is held liable, nor does it explain how the courts can decide whether solicitors who are careless and cause loss to their clients or to the beneficiaries, whether they owe a duty of care to these people, or whether a policeman or a security officer at a crowded event has a duty to prevent injury to people. Sometimes it's impossible to do. So liability is really endlessly extendable, and these principles are needed, and many more situations could arise the court has not yet considered. And do these all situations all create legal relations, and is it analogous to a manufacturer and a consumer? Lord Atkin, who was the main judge in Donoghue and Stevenson, says, in English law there must be a general conception of relations giving rise to duty of care, and particular cases found in books are but instances. Well, let me go on to foresight and proximity. So I've seen that these are the two key components of this test, and they are important in establishing liability. It's only the acts which the defendant could foresee might cause an injury to a claimant, which will mean there's a duty of care. It will be reasonably foreseeable. It can't be unreasonably foreseeable. A very, very unlikely event is not reasonably foreseeable. So reasonably foreseeable is enough. The defendant isn't obliged to take care in relation to acts or omissions which can cause harm to anyone, but only acts or omissions which can cause harm to his legal neighbour. Doesn't mean someone who lives next door to you in your area, but someone between whom there is proximity, between you and that person there's proximity. So the claimant has to be someone who should be in the contemplation of the defendant when an act or an omission causes harm. So let me see if these principles are applicable to the Donoghue case. So the first step is asking whether loss and injury is suffered, and yes, it definitely has been, because only then can there be damage. So the second issue is, was there a duty owed? Well, the duty of care was owed because the manufacturer have to make their goods in a way which is not going to cause injury. And there was a traumatic physical injury, gastroenteritis, and so that's very straightforward. That's an easy one. So the duty question in Donoghue was put this way. Did the manufacturers, who are the defendants, did they have a duty to take reasonable care in making their product? Well, what Lord Atkins said, there's a neighbour principle. The answer to this question is definitely yes, but there are two other questions. Was this reasonably foreseeable that a claimant would suffer some injury if a noxious thing, in this case a decomposed snail, was in the beverage? Well, yes, that's blatant. You'd suffer injury from that. The second issue was the claimant someone who the manufacturer ought to have in his contemplation when making the product? Well, yes, anyone who drinks it, that's who it's aimed at. So both issues were said yes to by the court. In Donoghue, the drink was in a bottle which was not transparent, so you couldn't see in. You couldn't see that the product was deeply defective. So it was reasonably foreseeable the failure to be sufficiently prudent and diligent in making this drink was going to cause an injury to someone. Then there's the issue of neighbourhood. The court found that since the intention was the product would reach the consumer and be drunk by someone, then the product must have the consumer in mind when making the product, which is why they try to make the product attractive and tasty and so on, because they're thinking, will the consumer like it? Will they want it? Will they come back for more? And then there's a proximity test. You've seen that closely connected to foresight and reasonable contemplation of harm, Lord Atkin underscored the need for a relationship of proximity between the parties. That doesn't mean that they have to be close spatially. Proximity is just a handy way of saying that there's some sort of relationship between them, as in the manufacturer and the end user, who's not necessarily the purchaser. And this shows that a duty of care is not owed in all cases where it's foreseeable in the absence of care someone may suffer some physical injury. There has to be proximity in as much as there's some degree of control or some responsibility for a possibly dangerous situation. That's enough at the moment. Toodaloo.